All right, y'all. So I decided to really knuckle down and work on a presentation that covers the return to duty process as a whole rather than just the FMCSA. Um, so this is our DOT SAP process training. Um, of course, I'm a SAP. I'm a licensed counselor with Addiction Recovery Solutions. Um, I know that you're new SAPs and looking to kind of sharpen your understanding of the federal compliance. So this session is designed more to give you the tools, the clarity, and confidence to navigate the return to duty process from start to finish. Today, we'll talk through the entire 6-step return to duty process with the emphasis on how to properly document compliance, communicate with employers, protect confidentiality. We'll also talk about some of the unique nuances that come up with working with different agencies like the FMCSA or the Coast Guard or with large employers like UPS. Let's get started by setting the stage of the overview of what the SAP process looks like and where your expertise is going to make the biggest impact. So, as a substance abuse professional, we hold a vital responsibility helping to safeguard public safety by guiding employees through the DOT return to duty process after a drug and alcohol violation. We'll walk you through what that process looks like from the moment the violation occurs to the employee's successful return to safety sensitive duties. That's a very, very specific term that you'll need to note in your reports. So we're going to break down the 6 steps with a special focus on step 5, where SAPs provide formal documentation of compliance. We'll talk about how to write that report, when to send it, what it must include, because that's the point where the SAP's judgment directly influences the return to duty decisions. In addition to that DOT framework, we'll look at how DOT and non-DOT cases differ, agency-specific variations like the FMCSA, FAA, FRA, FTA, PHMSA, and the United States Coast Guard. We'll look at unique employer expectations, including special cases like UPS, Walmart, or other military personnel, the role of third-party administrators and how they support or interface with the SAP's process. And most importantly, we'll review your obligations around confidentiality, specifically under the 49 CFR Part 40 and 42 CFR Part 2. By the end of today's training, I hope you walk away with a stronger understanding of both regulatory expectations and practical best practices so that you can carry out your SAP responsibilities with confidence, clarity, and clinical integrity. Let's begin with a quick overview of who we are and what the rules we operate under. The DOT qualified SAPs, our role is both clinical and compliance based. We're to evaluate employees who have violated the DOT alcohol and drug regulations and to determine using sound clinical judgment when that individual is truly safe to return to safety sensitive duties. Our work is grounded in federal law. Specifically, that's the 49 CFR Part 40, which outlines the exact steps and responsibilities we must follow in every case. The process is uniform across DOT agencies, whether we're working with a truck driver under FMCSA, a pilot under FAA, a train engineer under FRA, or a merchant mariner under United States Coast Guard. The framework's the same. A critical part of our role is maintaining confidentiality. Yes, the employer needs the confirmation and that the employee is compliant, but no, they don't get all the clinical details or treatment records. So that's where 42 CFR Part 2 comes in. It protects the employee's treatment information and restricts the disclosure unless a proper release of information is signed. We must obtain that written consent before speaking with treatment providers or disclosing anything beyond what's legally required. In our reports, we include what's allowed, factual details like the date of violation, date of evaluation, completion status, never diagnoses, counselor notes, or specific treatments. So now that we've established that foundation, let's walk through the 6 core steps of the DOT return to duty process. With this, do not be confused with the clearinghouse 6-step return to duty process. That it sounds very similar, okay? So the DOT return to duty process is a federally regulated 6-step pathway that every safety sensitive employee must complete after a violation of DOT drug or alcohol regulations and while each step matters, step 5, which is what we'll highlight on the next slide, is where SAPs have a heightened responsibility. We'll walk through the entire flow to see how it all fits together. So step 1 is the immediate removal from safety sensitive duties. As soon as there's a verified positive test, like a blood alcohol confirmation of 0.04 or higher, or a refusal to test, the employer must remove that employee from all safety sensitive duties immediately. That's non-negotiable under the DOT rules. The employee cannot perform any safety sensitive functions until the entire return to duty process is complete. Whether it's a truck driver, a pipeline worker, or a train operator, once the violation is confirmed, they're benched. Even though that SAPs aren't involved at this point, it's our job to reinforce the seriousness of this step with help employers and clients understand there's a zero tolerance here. Public safety and regulatory compliance are on the line. Step 2 is that the employer provides the SAP information. At this point, the employer or their designated employee representative, their DER, must provide the employee with a list of qualified DOT substance abuse professionals. They're not allowed to steer, influence, or recommend a particular SAP, only provide names and contact information. Many companies use a third-party administrator or a TPA to help with this process, but the bottom line is that the employee must make the appointment. If you're mentoring employers, make sure that they understand those boundaries. This step isn't about guidance or coaching, it's about ensuring that the access to a list and stepping aside so that the employee can take action. That handoff is what gets the ball rolling for us as SAPs. So step 3, the SAP initial evaluation, is where we step into our official role. The employee meets with a DOT qualified SAP, either in person or via approved remote platforms, for a comprehensive evaluation. This assessment includes a biopsychosocial interview, validated screening tools, substance use history, and sometimes collateral input. That could be a report from a doctor. It could be the drug test, the drug test violation. It could be a letter from the employer. It could be EAP documentation. So there's sometimes collateral information that we will take, and I just put it in their file. Based on clinical findings, we will find an appropriate course of treatment or education, ranging from a one-time class to outpatient counseling or even inpatient rehab, depending on the severity. We explain this recommendation clearly to the employee, help them understand that this is their roadmap back to work. Following that assessment, we prepare a SAP report, the initial SAP report, also called the initial evaluation report. That report is signed, dated, and printed on the SAP's letterhead. It includes the employee's name, violation type, employer, date of evaluation, and our recommendations, but no diagnosis or sensitive clinical details. Per 49 CFR 40.311, this report is sent directly to the designated employer representative, not through the TPA. Unless it's an owner-operator case where those exceptions apply, you can copy the TPA if requested, but the DER must always receive the official copy directly from you, just in case anybody tries to alter it in between. That is sad, but it happens. This report sets the plan into motion, and it must be factual, concise, and compliant. Step 4, completion of treatment education. So this is the employee's responsibility. They must enroll and successfully complete the program we recommend. While we may offer referrals, we do not provide treatment ourselves. Our role is that of an evaluator, not a therapist. So that said, we can and should stay informed on their progress. Certificate of completion, discharge summary, provide a letter or provider letter. We must confirm that the employee has met all the requirements. In some cases, we may conduct a follow-up interview or consult with the counselor to ensure the spirit and the letter of the recommendation were fulfilled. So keep in mind, DOT doesn't assign financial responsibility for treatment. That could fall on the employee, the employer, or insurance. Our concern isn't who pays. It's that the employee completes the program. Once that's verified, we're ready to move to the next step, and that's where our clinical authority comes back into play. Step 5, the follow-up evaluation and reporting compliance, is one of the most critical in the entire DOT return to duty process. This is where, as SAPs, we determine whether the employee has successfully complied with our treatment or education recommendations and whether they're ready to return to safety-sensitive duties. Once the employee completes their program, we conduct a follow-up evaluation. That's a face-to-face reassessment that includes reviewing documentation of completion, possibly consulting with their treatment provider, and evaluating their overall readiness. This isn't just about whether they check the box. We look at attitude, insight, cooperation, and whether they've taken the process seriously. If based on our clinical judgment, the employee has demonstrated successful compliance, we move forward with preparing the SAP report number 2, the follow-up evaluation report. That document is what officially clears the way for return to duty testing. Under 49 CFR 40.311, that report must include the dates of the initial and follow-up evaluations, a synopsis of the treatment or education plan, confirmation of completion, including attendance dates, and a brief characterization, such as attended all sessions, demonstrated a cooperative attitude, are a couple of examples. It should include our clinical determination that the employee has complied and the follow-up testing plan. So let's talk about that testing plan. DOT requires a minimum of 6 unannounced tests during the first 12 months back on the job. But as SAPs, we have discretion to require more frequent testing and to extend that plan up to 5 years. This is one of the most powerful tools we have to support ongoing accountability and relapse prevention. Once finalized, the SAP follow-up evaluation report must be sent directly to the designated employee representative, or DER. If the employee is currently unemployed, we send the report directly to them. Per subsection 40.311F, just like with report number 1 or the initial evaluation report, we don't go through a TPA unless it's an owner-operator situation with proper permissions. This step is where our clinical judgment meets regulatory responsibility. It's the bridge between rehabilitation and reintegration, and it must be handled with clarity, accuracy, and zero shortcuts. I also want to say on the follow-up evaluation report, when you send that to the client, do not include the follow-up testing plan. You just send the report, not the follow-up testing plan. You'll only send the follow-up testing plan to the designated employer representative and TPA. All right. Confidentiality, communication, non-compliance. Let's go a little bit deeper into what that makes step 5 in being such a critical responsibility for us as SAPs, and why our attention to confidentiality and clear communication matters just as much as our clinical judgment. When we prepare and send a compliance report to the employer, the designated employer representative, we must ensure that we're following both 49 CFR Part 40 and 42 CFR Part 2. These federal regulations make it clear that the employer is only entitled to know whether the employee has complied and what that follow-up testing plan is, nothing more. Even if we reviewed counseling notes or discharge paperwork from a treatment provider, we do not forward that to the employer. Our report should never include diagnosis, therapy notes, personal commentary. We might say the employee successfully completed the recommended outpatient program and demonstrated a cooperative attitude, but that's it. It's best practice and required under 42 CFR Part 2 to include a disclosure disclaimer anytime we send a written communication. I use something like this. This information is provided in accordance with DOT regulations for the sole purpose of determining return to duty eligibility. It must be kept confidential and may not be redisclosed except as permitted by law. Now, when we communicate with the designated employer representative, we keep it professional and fact-based. Whether by phone or in writing, the conversation focuses on three things: the employee complied, the follow-up testing plan, they are now eligible for the return to duty test. What we don't do is share side comments like they really struggled with counseling or they were diagnosed with X, Y, and Z. Even with consent, it's our duty to stick to only what's required by law. Okay? And remember that if the employee didn't comply, maybe they dropped out of treatment or failed to meet all the requirements, then our report says just that. The employee did not complete the SAP's recommendations and it is not eligible to return to duty at this time. No extra detail, no judgment, just a clear statement of non-compliance. Employers can't move forward without this report. So in many ways, step 5 is our stamp of clinical accountability. If we say the employee is ready and they've done the work, we give the green light to move to step 6. If they haven't, we pause the process until they're truly ready. This is where professionalism, regulatory knowledge, and ethical boundaries all converge. It's not just about writing a report, it's about protecting the employee's privacy, keeping the employer compliant, and maintaining the integrity of the entire return to duty process. So step 6 is the final piece in the return to duty process, the moment the employee has been working toward. It starts with the return to duty test itself. Once the employer receives our SAP compliance report, they're authorized to schedule this return to duty test immediately. If the violation was drug related, it must be a directly observed urine test per DOT rules. If it was alcohol related, it's a breath alcohol test. This is non-negotiable requirement. No observations, waivers, or drug tests are available at this stage. The purpose is to protect the integrity of the testing process. If the return to duty test is negative, the employer can officially return that employee to safety sensitive duties, usually on the next scheduled shift or in accordance with the company policy. That's when the technical return to duty process is considered complete. But here's what I tell employers and employees. Just because the return to duty test is over doesn't mean that we're done. Now begins the follow-up testing plan and is where our authority continues forward. As SAPs, we as SAPs design the follow-up testing schedule. DOT requires a minimum of 6 announced tests within the first 12 months, but we can and should prescribe more if clinically appropriate. That testing window can extend up to 5 years total. So for example, I might recommend 6 tests in 1 year, then 4 in year 2, depending on the case. The employer is responsible for ensuring that these follow-up tests are carried out exactly as written. They often use a TPA to manage the logistics and place the employee in a separate follow-up testing pool, not the same pool used for randoms. These tests must be unannounced and the employee should have no forewarning other than perhaps being told how many they'll face. Actually, I'm sorry. The test should be unannounced and the employee should have no forewarning, period. A positive test on any follow-up test is treated as a new violation and the process starts over. That's why I'm clear during the follow-up evaluation. Your return to duty test is coming and the follow-ups are real. You need to stay clean because one slip means starting over. and possibly losing your job permanently. That's also why, as a SAP, I have them do a non-DOT test before I send them to do the return to duty test. Also, before I do the follow-up evaluation, so that I'm covered as a clinician saying, okay, they do not have the drugs in their system. They are clear to return to duty. That way I'm not setting them up to fail in case like they use marijuana and it's maybe some traces still in their system. They go and they fail that return to duty test. They'd have to start all the way over. So once all the follow-up tests are completed and all of the results are negative, the employee reverts to a standard random testing like everyone else. At that point, they're fully restored and reintegrated into the workforce. Usually our active role at SAP typically ends, but I suggest that you remain available to the employer or TPA if questions arise. We don't usually conduct further evaluations unless there's a new evaluation, or I'm sorry, a new violation. Still, we carry that responsibility of keeping clear records for 5 years. That's part of our compliance. So I want to shift gears and talk about something that trips up a lot of new SAPs, and that's the difference between DOT evaluations and non-DOT evaluations. We work both sides, or we can work both sides. We serve DOT regulated employees, and we also evaluate people referred by private employers, courts, or EAPs. But while the clinical skills may overlap, the rules, reporting, and responsibility is very different. So here's the bottom line. DOT evaluations are federally regulated. Non-DOT evaluations are governed by employer policy, state law, court orders. There's not a single standard. So let's break some of this down. Regulatory framework, DOT evaluations are built on 49 CFR Part 40. They're federally standardized and apply across all transportation agencies, the FMCSA, the FAA, FRA, PHMSA, FTA, and USCG. Non-DOT evaluations follow whatever rules that the employee or the employer or referring agency sets. Sometimes it's influenced by state law, insurance policies, or HR guidelines. So DOT is a strict federal blueprint. Non-DOT is more like a company's custom playbook. For DOT cases, you must be a qualified SAP. That's a licensed or certified, to be licensed or certified in a behavioral health field, trained in DOT regulations, tested on the material, and maintaining that continuing education. Non-DOT evaluations don't have those federal qualifications. As a private employer might use an EAP counselor or another licensed professional. The term SAP legally applies only to DOT. All DOT SAPs are substance abuse professionals, but not all. Okay, let me back up. All DOT SAPs are substance abuse specialists, but not all specialists are SAPs. That makes sense? In DOT cases, that 6-step return to duty process must be followed exactly. You conduct an initial evaluation, make a clinical recommendation, verify that treatment completion, conduct a follow-up evaluation, and submit 2 formal reports. One to start, one to clear return. You prescribe a follow-up testing plan, and the employer must carry that out. In non-DOT cases, the process might be informal. The employer could ask for a one-time assessment and a fit for duty note, or they might mirror the DOT process voluntarily. The format of the report is up to them. Some just want a confirmation that the employee completed treatment. DOT requires follow-up testing. Non-DOT employers may or may not. It's optional unless written into that company policy. So with consequences, in DOT cases, if you test positive, you're out of safety sensitive duty nationwide. Until you complete the SAP process, no exceptions. And for FMCSA commercial drivers, it gets logged in the clearinghouse. The clearinghouse is a federal database that follows you between jobs. In non-DOT, the consequences are set by the employer. They might fire the employee, give them a second chance, or ignore a first offense. There's no federal registry for a non-DOT violation. So if you're fired, you might get rehired somewhere else, unless your old employer shares the reason in a reference. In DOT, only a qualified SAP can say when somebody's ready to return. That decision must be independent, no employer influence. In non-DOT, the employer might accept a discharge summary, a letter from a rehab center, or just a counselor's note. They might not require a follow-up evaluation. It depends on their policy. DOT SAPs can be audited by DOT regulators. Your reports might be reviewed by FMCSA or FAA during a compliance check. Non-DOT programs aren't federally audited, but your documentation could come up in a legal case or HR disputes. Confidentiality is critical in both, but in DOT, Part 40 specifically allows sharing limited compliance info with employers. In non-DOT, you're following the standard HIPAA and 42 CFR Part 2, and everything hinges on that signed consent. So here's an example. Let's say a CDL driver fails a DOT test. They're immediately removed from duty, referred to a SAP, entered into the clearinghouse, and can't drive until they complete the full process and test negative. Now, let's say an office employee at a private company fails a drug test. The employer might refer them to an EAP, require treatment, or just terminate them. If kept, they might need a basic return to work note and maybe a few follow-up tests if the company chooses. Key takeaway is DOT evaluations are formal, regulated, and tied to public safety. Non-DOT evaluations are flexible and employer-driven. Our counseling skills are valuable in both, but the legal and procedural responsibilities are not interchangeable. And for those of you mentoring others, make sure that you know that being a licensed counselor is not the same as being a DOT SAP. You have to meet the DOT training, testing, and renewal requirements. That said, many of us use the same best practices in both settings. Even in non-DOT cases, I recommend doing a full evaluation, making formal recommendations, and offering a follow-up because it's just good clinical care. But always clarify which rules you're operating under, because that affects how you report, what you can disclose, and who decides when someone's ready to return to work. Now that we've covered the general SAP process, it's important to recognize that 49 CFR Part 40 sets the standard for all DOT regulated evaluations. Each DOT agency has its own context, procedures, and special rules that we as SAPs need to understand. Whether you're working with a truck driver, a pilot, or a mariner, your clinical process may be the same, but the real world implications can be different. So let's walk through some of those key DOT modes and what you need to watch out for. The FMCSA, trucking and bus transit, this is probably one of the most common modes for us, CDL holders operating in interstate commerce. The big differentiator here is the FMCSA clearinghouse. If you're not registered, you need to be. SAPs are required to enter two key dates, the initial assessment and the determination of compliance. That's how future employers know if a driver still has open SAP requirements or if they are cleared to drive. Also be prepared to work with owner operators where you'll often be sending reports to TPAs instead of the traditional DER. That's allowed under DOT rules, just document carefully. When it comes to UPSs or other unionized carriers, be aware that there are often additional timelines and union procedures layered over the DOT requirements. Still, your responsibility is to complete and report the SAP process clearly and on time. FAA, this is aviation. That's your pilots, mechanics, and controllers who fall under FAA. These are high liability cases, particularly pilots who may lose their medical certificate or their pilot's license due to a positive test. You may complete the SAP process, but they still need clearance from the FAA via the HIMSS program, which is a separate, highly structured recovery and monitoring system. If you're not HIMSS trained, don't worry. Just refer the pilot to a HIMSS AME and coordinate as needed. Your documentation should be clear, professional, and suitable for regulatory review, as it may be submitted as part of their case for license or medical reinstatement. FRA, railroads. Railroad workers are unique because of the 9-month mandatory revocation for engineers and conductors. Even if you clear someone in 3 months, they can't return to duty in that role until the full 9 months is up. So let clients know about this up front so they don't have those unrealistic expectations. You'll often interact with the medical directors or safety officers, and FRA does conduct audits. Your documentation needs to be bulletproof, especially follow-up plans. I've been audited by FRA. It went good, thankfully. All right. FTA, public transit. Transit agencies operate under Part 655 in addition to Part 40. The SAP process is the same, but you might be dealing with municipal employers, unions, and civil service rules. Make sure you know who the DER is. Sometimes it's a DAPM or someone from HR. Transit agencies are frequently audited, so they tend to follow protocols closely. Still, stay firm about SAP specific responsibilities, especially if there's an overlap with EAPs. DAPM is a drug and alcohol program manager. PHMSA, these are pipeline operations. Pipeline cases are less frequent, but just as serious. You might be evaluating a controller, a technician, or a field operator. There's no clearinghouse here, and the process is straightforward, but many companies rely on the third-party administrators to coordinate the SAP steps, especially smaller operators. Always confirm where to send your reports and copy the TPA when appropriate. Watch out for dual-role employees. For example, someone who works on pipelines and also drives commercial vehicles. That one violation may affect both roles under PHMSA and FMCSA. United States Coast Guard, or maritime. Maritime cases include merchant mariners, tugboat crews, and offshore oil workers. What's unique here is that the failed test might result in the suspension of a mariner credential, not just job loss. The Coast Guard may require a copy of your follow-up report or other documentation to reinstate the person's credentials. Sometimes your report will not just go to the employer, but to the Marine Safety Office with signed consent, of course. And if the mariner is between voyages, they may not have the current employer, which means per Part 40.311F, you send the report to the individual directly and advise them to retain as and share as needed. We went over that United States Coast Guard letter with the maritime and the laws. That's what this is pertaining to here. Military involved cases. These are rare, but worth noting. If someone is both a service member and a DOT regulated civilian employee, say a reservist who's failed a test at their day job, they may face consequences of both sides. Our role stays the same. We complete the SAP process and maintain confidentiality under 42 CFR Part 2. We do not report anything to a military commander without proper legal consent. If they ask, you can encourage them to self-report or utilize military support services, but you don't break confidentiality unless legally obligated. So the SAP process is consistent, but the context matters. Who you're reporting to and what agencies are involved, the consequences the employee might face. Those things, they can vary pretty significantly. So always ask, what agency or DOT mode does this person fall under? Who's the DER? Is there a union or regulatory oversight that might impact the timelines or follow-up? What does full compliance look like for this person, both on paper and in practice? And with that level of awareness, you'll not only protect your license, you'll provide a truly more informed and ethical guidance that can help people get their careers and lives back on track. Third-party administrators, or TPAs. They're an essential part of the DOT testing ecosystem, especially for small employers and owner-operators. A consortium TPA or a CTPA handles administrative duties of an employer's DOT and alcohol testing program. That includes things like maintaining test records, scheduling randoms, coordinating with labs and MROs, and often helping employers understand their responsibilities under 49 CFR Part 40. If you worked with a smaller trucking company or independent contractors, you've likely dealt with TPAs already. They're especially critical for owner operators who legally cannot manage their own compliance without a consortium in place. What's their role in the SAP process? They may refer employees to a SAP, especially when the employer does not maintain their own SAP list. They typically coordinate the follow-up testing plan once the employee returns to duty based on the SAP's written plan. In owner-operator cases, they act as the receiving party for the SAP reports because the driver is essentially their own DER. Now, they may coordinate it, but the employer has to send them for it. So while they're often in the loop, they're not the employer. So that brings us to a pretty legal distinction. The TPA is not the DER. Only the designated employee representative, which is usually someone at the company with the decision-making authority, only them can make fitness for duty decisions, authorize removal from duty, and receive SAP reports in most cases. Now, that may be the HR, that may be the owner, that may be their boss, supervisor, safety compliance. There is someone that is legally designated as their designated employee representative. So say in a case where the HR is their designated employee representative, and then you have the supervisor calling about the client and when they're going to return to work. Can you tell that supervisor when they're going to return to work? Can't talk to them about it. All right. So per DOT regulations, SAP reports must be sent directly to the DER, not only to the TPA. You can CC the TPA, and often you should for coordination, but they cannot act as a bottleneck or substitute for employer communication. The only exception is in the owner-operator cases where the TPA may serve as the point of contact in lieu of an employer. What does that mean for us? If a TPA refers an employer to you, send your initial and follow-up reports directly to the DER. CC the TPA for coordination, but never send it only to them unless it's an owner-operator case, in which case document it clearly. Use disclaimers like the report is provided directly to the DER in compliance with 49 CFR Part 40. As a courtesy copy is included to the TPA for program coordination purposes. Confidentiality still applies. TPAs are considered service agents and must follow the same privacy rules as employers. Only share what is necessary, like your official SAP report and the follow-up testing plan. Never include diagnosis, treatment details, or personal information. And make sure that you're transmitting those securely. Most TPAs use encrypted emails, portals. Most TPAs use encrypted email portals or secure fax. Don't send sensitive reports through open channels. What TPAs do well is keep the employers compliant with random and follow-up testing, track testing schedules, due dates, and documentation, educate small employers on their obligations, and coordinate clearinghouse actions on behalf of the FMCSA employers. What they can't do is modify your clinical recommendations. If a TPA ever says, can you drop the follow-up tests, follow-ups to 3 tests instead of 6 to make it easier? I've been asked this. No. That's a red flag, and DOT requires at least 6 unannounced tests in the first 12 months, no exceptions. Your judgment must remain independent and informed by clinical evidence, not convenience. I've had employers call me and say, well, this this employee is going to require too much drug testing. We're not going to hire them. Had to leave it. I know that kind of puts you in a position of where you feel like you may be doing them harm, but that is the law and that's what's required. Okay. So the bottom line is that good TPAs are pretty invaluable. They smooth out the admin work and help close the loop between employers, labs, and SAPs. But your obligation is always to follow the law, protect confidentiality, and maintain clinical independence. You can build a strong working relationship with TPAs, and you should, but always keep your responsibility to the employee, public safety, and the regulations front and center. So as we wrap up this training, I want to focus on some of the best practices that keep us ethical, effective, and compliant, especially when it comes to documentation, communication, and confidentiality. This is where clinical judgment meets administrative responsibility. DOT gives us the rules, 49 CFR Part 40 and 42 CFR Part 2. But how we implement them determines on the quality of our work and the safety of the system we support. Every SAP Every SAP report must be on your letterhead, signed and dated. It must include all items required under Part 40. That means employee and employer info, violation details, dates of assessment and follow-up, recommendation or compliance determination, follow-up testing plans. Use a checklist or standardized template to avoid missing anything, and always document whether the eval was in person or remote. DOT allows telehealth SAP evaluations, but you must indicate that in your report. Also, keep a record of how and when you sent each report and retain a copy for at least 5 years. I personally suggest organizing reports in a way that would make an audit easy to pass, have them retrievable and clear. Consent forms. Before you contact an employer, treatment provider, or TPA, you need a written consent from the employee. This is a must under 42 CFR Part 2. Each consent should specify who the information is being released to, what is being disclosed, the purpose of the disclosure, the employer's signature and date. Any disclosure should include Part 2 redisclosure warning, even if it's just on your cover letter. This information is protected by federal confidentiality rules and may not be redisclosed without permission. So confidentiality is not optional. It's the backbone of our work. You can tell the employer whether the employee completed the program, but you cannot tell them what the employee said in therapy, their diagnosis, or how many AA meetings, what they said at the AA meetings. Even in casual conversations, like when someone says, "How's Joe doing?" The answer is, "I'm sorry, I can't discuss that without permission." If the employee needs documentation, it should come from your structured signed report, not a verbal update or quick text. Also, safeguard your files, password protected digital records, lock up your physical files, and when you eventually dispose of them, do it securely. When working with DERs, be timely. If the employee completes treatment and you determine compliance, don't sit on the report. The delay can hold up their job and affect the employer's ability to make safe staffing decisions. Be clear and concise. Avoid the clinical jargon. Don't say the prognosis for a relapse within a normative range. Just say what's required. The employee successfully completed the SAP recommendation and is now eligible for a return to duty test. When laying out the follow-up testing plan, I use bullet points such as at least 6 unannounced tests in the first 12 months, a minimum of 3 tests in the first 6 months, additional testing as clinically indicated throughout 24 months, something along those lines. If a DER is unsure of what to do next, coach them respectfully. Now that the employee has been deemed compliant, your responsibility is to schedule. This is an example of what you can say to them. Now that the employee has been deemed compliant, your responsibility is to schedule the return to duty test under direct observation and implement the follow-up testing plan I provided. So this isn't overstepping, it's just ensuring compliance. Um, when communicating records, note every significant phone call, follow up with an email confirming what was discussed, never include more detail than necessary. Just put just enough to document that the communication occurred. That protects you, the employee, and the employer. Uh, Stay current on regulations. DOT guidance can change, like the permanent removal of or the permanent approval of remote evaluations or changes in the drug panel. Make it a habit to check ODAPC updates and stay up to date with your SAP requalification training. Also know the limit of what goes into a report. For example, DOT requires clinical characterization of participation. That can be as simple as the employee actively participated and successfully completed the outpatient program. But what doesn't belong? The employee initially resisted treatment and later opened up about childhood trauma. That may be relevant clinically, but not for the employer. When there are multiple stakeholders, like if a union rep, attorney, or EAP is involved, always clarify with the employee what can be shared and with whom. Don't assume you can discuss the case with anyone other than the DER without explicit written permission. If an attorney calls, don't share anything without a proper release or legal directive. 42 CFR Part 2 requires a specific court order with detailed findings before you can release clinical information. And even then, consult legal counsel before complying. So these ethical and tough decisions, sometimes we have to say no. Even if an employee completed the sessions but shows no insight or no effort, you can and should require more. You're not just checking boxes, you're protecting public safety. And if you ever feel uncertain, reach out, consult with experienced SAPs, reach out to ODAPC, or even consult legal guidance if needed. Keep improving. Motivational interviewing, relapse prevention techniques, they aren't required, but they make us better. Better at assessing, better at engaging, better at helping. And always remember that what we do matters. We're not just evaluating a person, we're helping them rebuild trust, return to safety sensitive work, and in many cases, restart their lives. That brings us to the end of this DOT SAP coaching course. Over the past slides, we've walked through the full return to duty process from initial evaluation through treatment, follow-up evaluations, reporting, and the final steps. We've highlighted the critical importance of step 5, clarified the differences between DOT and non-DOT cases, and unpacked the unique challenges across various DOT agencies like the FMCSA, FAA, FRA, FTA, PHMSA, and United States Coast Guard. What ties it all together is our role as qualified SAPs, rooted in the framework of 49 CFR Part 40 by the confidentiality protections of 42 CFR Part 2, and being committed to helping employees restore both their careers and their integrity. We don't just check boxes, we assess, we document, we guide, we protect. In every case we handle is an opportunity to uphold public safety while offering a path forward to someone who depends on getting this right. So let's carry that responsibility with care. We stay up to date with DOT guidance. We support one another in complex or challenging cases. We don't forget that our diligence and our integrity builds trust in the SAP process and strengthens the entire DOT testing system. So thank you for your time, your attention, and the work you're going to be doing. So I'd like to open the floor for any questions, scenarios, discussion, or whether it's a tough case or maybe a tough case that you feel like you may run into, or any clarification that you need.
It's pretty good.